I'm here sui juris in propria persona. I reserve all rights. I, Jonathan hyphen Troy Faithfulleos Liatoa Colin Schuster, comma beneficiary and sovereign, and here under fraud, menace, and duress. Fiduciary advocate.
Let's pick up where things were left off. Today's coverage dives into another unusual courtroom moment involving an individual well known for his unconventional legal beliefs. Several viewers reached out asking for a breakdown of this case, and after reviewing the footage, it's definitely worth a closer look. The person at the center of today's story is someone we've examined previously, a Washington resident named Jonathan Schuster. In past hearings, he introduced himself as an American Samoan, suggesting that this status placed him outside the jurisdiction of U.S. law. However, regardless of personal interpretations or scripted statements displayed on a phone, American law applies to all American nationals without exception. Courts do not adjust legal authority based on self-declared distinctions that we've already analyzed as arraignment in an earlier video, where many of these claims first surfaced. But today, we're moving forward with 2 additional hearings, each offering new moments that reveal how the legal system responds when someone insists on ideas that do not align with established law.so. With all that in mind, let's start breaking down what happened in these next proceedings and explore how the court handled each step of the process.
This is a Social Security Certificate Trust action, which you are now a real party and interest to. I'm here sui juris in propria persona. I've challenged the jurisdiction of this court, and I don't understand. So I do need some questions answered. Is there a bond on this matter?
I believe you were PR. Actually, bail was set at $2,000.
There is a bond on this matter, correct?
Yes, there is.
Okay, and so is my social security number attached to these charges in any way?
I don't believe so.
You don't believe so?
I don't have any record of your social security number. So as far as I know, I don't know your social security number.
No, I'm saying, is my social security number attached to these charges in any way?
Only in the extent that it's connected to your driving history.
So is that a yes or a no?
In some way, shape, or form, your social security number is in the system with records on you. That is true.
Okay, so you just told me there was a bond, which means this is commercial court.
It's not commercial.
Now you're saying that my social security number is attached to these charges. And so, which means this is a Sesticate Trust action, which you are a real party in interest to. And I just told you I was the beneficiary. You're supposed to be charging the trust. You're not charging the beneficiary. And if you're creating bonds against my trust without my permission, I don't understand. Are you saying you're committing fraud trust?
Well, that really depends on whether the court will take a moment to explain what a fraudulent trust claim actually means. It's a topic that often confuses people, especially when legal terminology is used in ways that don't match how the law functions. Clear definitions matter, and misunderstandings can spread quickly when complex ideas get repeated without proper context. In the previous hearing, we saw an example of this confusion when the defendant accused the judge of operating outside the law, a statement that didn't align with how judicial authority actually works. The court follows established legal procedures, and any claim suggesting otherwise needs to be supported by real evidence, not assumptions or personal interpretations. This new exchange highlights the ongoing tension between the court's effort to keep the record accurate and the defendant's insistence on using terminology that doesn't fit the legal framework. Moments like these often create unnecessary friction, making it important for observers to separate legitimate legal arguments from statements that don't carry legal weight.
Noted.
You cannot enter a plea for somebody that is, practicing bench from the law.
I'm saying that you are subject to the jurisdiction of this court.
This matter cannot move until you've proven jurisdiction, and you failed to do so. And if you cannot prove jurisdiction, then this matter needs to be dismissed with prejudice because this is a commercial matter. I'm a non-U.S. citizen American national by way of American Samoa. I'm beneficiary. I am here sui juris in propria persona, and we cannot move any further on this matter until this is either dismissed with prejudice or you can prove jurisdiction.
So what would you like to do with your case? I assume, Mr. Parent, that you are not representing
So,
cannot speak for me. Like
Okay,
I said.
he's not speaking for you, but I am asking him a direct question, so I need you to let him answer.
Okay,
yes, so the court did appoint us on this matter. But it sounds like he does not want my office to represent him, so I'm happy to withdraw.
you can dismiss yourself.
So would you like to represent yourself in the matter, Mr.
Please do
Schuster?
not tell me to shut up. You can dismiss yourself.
So he can't dismiss himself, only I can dismiss him. I'm asking you if you wish to have an attorney or if you wish to represent yourself.
This is a trust or sophisticated trust action. And so I'm here sui juris in pro persona. You know what that means. And so we can prove.
Don't know what it means because it's nonsense, but nonetheless.
Prove jurisdiction, or we can dismiss this matter with prejudice.
So I'm not going to do that today. Here are your choices. You can have Mr. Parent represent you. You can choose to obtain private counsel, or you can represent yourself. Let's start there. Which of those
Nobody's
three?
going to represent me. I can present myself, as I
Okay.
said.
So you want,
initially.
so you wish to go pro se? I don't need you to read the script. I need you to tell me if you wish to go pro se.
I told you, I'm here sui juris in pro persona.
Ms. Roberts, are you there?
Yes, Judge.
My inclination is to set this matter over and see if Mr. Schuster wants to give it another shot with his attorney or go pro se. It looks like this is the first pretrial. I suspect he's not prepared to set for trial today.
What is the first one? There's no plead.
Okay, I'm not speaking to you, so you're gonna have to wait. I'm speaking to Ms. Roberts.
I mean,
Judge, I would ask that we set this matter over 1 week.
Do you want to come back to court in 1 week and try again?
we can finish this matter now.
We
There's no
can't.
need to
We
move
can't.
this any further, because
So here's
it's
the
not
thing.
proven jurisdiction.
Here's the thing. It's not my position today to have to prove jurisdiction to you.
It is. It is your position, because
it's
it is
not.
on the courts.
And I'm also not going to argue with you.
There's no
So
arguing.
I'm going to have you come back to court in 1 week.
There's nothing you can prove that you have jurisdiction. This man does not speak for me.
So we're going to come back to court on July 1st.
That date doesn't work,
Why doesn't it work for you?
because I'm a man. I have things to do. And I have no more time for this matter. And unless you can prove jurisdiction, there's no need for this matter to move any further.
But you're going to come back on July 1st at 9 a.m. If you don't come back on July 1st,
Are you
then
threatening me now?
I'm telling you, there's going to be a bench warrant issued if you don't show
Are you
up. So
threatening me now?
I'm giving you the choice of showing up
No,
or a
I'm
bench
giving
warrant
you the
issuing.
choice to finish this matter now or be responsible for your actions.
We'll set this for July 1st. I'm
Would you
going
like
to,
to be responsible for your actions and set this further? Because you can do that, or you can dismiss this matter with prejudice.
I'm not going to do that today. So July 1st, 9 a.m. back in
Now
this
you're
courtroom.
threatening me. Abigail, what's the reason for the threats, Abigail? You violated my rights enough.
We'll just hold Speedy for this
You
week, Ms.
violated my
Roberts.
rights enough. This matter needs to be dismissed with prejudice,
We'll see you back on July 1st,
or else what? You're gonna threaten me?
or else the court will issue a bench
So
warrant.
you're threatening me now, Abigail.
I am telling you your
I'm telling you,
options.
this matter needs to be dismissed with prejudice. Because you cannot prove jurisdiction. This is a
Signature here.
sophisticated trust action.
Signature here,
You're trying
please,
to
sir.
commit fraud.
Sir,
You're
Mr.
trying to
Schuster.
commit fraud. Miss, I'm
So-
speaking with Abigail.
You're done.
No,
you're done.
you can't tell me I'm done.
I
This
can.
is no, you don't have power to do that.
Your court case is
You
over.
don't have power to do that.
Sir, your hearing is over. If you don't take your paperwork and leave the courtroom, we'll have you remanded into custody.
You're threatening me now,
I'm
even more so
Giving you
than
a
you already
choice.
were. And if anybody tries to touch me, I'll charge them with assault and battery. So I will be gone because this matter is.
But let's be honest. It's clear he came into the hearing with a rehearsed script pulled up on his phone, ready to deliver each line as if it were part of a planned presentation. If someone is going to rely on written prompts like that, the least they could do is ensure the information is grounded in actual law rather than ideas that simply don't exist within any recognized legal framework. This moment shows the difference between genuine legal research and arguments built around terms that have no standing in court. When claims rest on concepts that hold no legal authority, it becomes increasingly difficult for the judge to move the proceedings forward in a productive way. It emphasizes how important accurate information is when someone chooses to represent themselves.
Let's address. We can address Jonathan Schuster, 480525748.
For the record, this man.
Why don't you come up to council table, please, so we can create a record?
No, I don't want to and give you any personal jurisdiction, so I'll stay right here.
No, you'll come to the council table if you would like to be heard and make a record. So you need to come up and turn on the microphone.
No, I don't need to do that for me to be heard.
We are audio recording, so to be heard, you need to come up to the table and sit with the microphone.
You don't have to, I don't have to come up there for you to hear me. You can hear me perfectly fine.
I can hear you, but we are creating a court record, which is audio recording.
Jurisdiction by doing what you said, because you don't have jurisdiction over me. And so, for the record,
Mr. Schuster, I
reserve all rights.
I did put Mr. Parent as standby counsel. Right now, you don't represent yourself. You have standby counsel.
Appoint counsel to me
Well,
without my permission. He has no permission to be my counsel. I'm here sui juris, appropriate persona. I, Jonathan Troy Colin Schuster, am here under fraud, menace, and duress. I have made a special appearance to this court for those reasons. I've challenged the jurisdiction of this court, and you have not answered that challenge, Ms. Jennifer. And so I have some questions for you.
well, right now,
To answer them?
I am not here to be interrogated by you. You are under the jurisdiction of this.
Going on here.
I think you understand and you choose not to
I do
take
not
in the information.
understand
Okay, well,
what's going on
Mr.
here.
Schuster,
I don't understand the nature and cause of what's going on. I don't understand how you can practice law from the bench. I don't understand how you can appoint counsel when I've told you over and over and over again that I'm here sui juris appropriate persona. I'm here of my own right, in my proper person. He does not have my permission to represent me in any way.
well, it doesn't sound like you know how to represent yourself either, which you would,
represent myself.
well, you would. Either you have counsel or you are acting pro
Represent
se.
myself. And so, like I have told you, I'm here sui juris appropriate persona. I have challenged the jurisdiction of this court. You have not answered that challenge. We cannot move any further until you've answered that challenge. Is this common law jurisdiction, or is this an admiralty maritime jurisdiction?
Either. So,
Right.
Mr. Schuster, this is Carmen McDonald. I'm the prosecutor on this particular case. I think where we're at right now is you're being charged with an offense. I can barely hear you, which means the record that you're trying to make is not being picked up and not being recorded. So everything you're saying is not being preserved unless you go to the table up there near the microphone. So that's number one.
For the record, I reserve
if you would
all my
like-
rights. If you
If you would like,
I will
if you,
step up so you can hear me better, and I will
none of
speak
it's being,
louder.
none of it's being
I will
preserved.
speak louder so you can hear me, but I reserve all my rights. And I'm speaking much louder than anybody else prior to me has spoken.
Mr.
So I just
Schuster,
want to make sure that
Mr.
the
Schuster,
reporter can hear
you
me.
are making legal arguments. All right, you are making legal arguments. They should be preserved for the record, which means it needs to be picked up and recorded.
I will
so-
begin again so that the recorder
You're
can
not
hear me.
choosing to be silent, you're choosing to make a legal argument, so we need to have that on the record.
For the record, I reserve all rights.
You've made that,
I, Jonathan Troy Colin Schuster, have made a special appearance under fraud, menace, and duress. Fiduciary Jennifer. I've challenged the jurisdiction of this court, which has not been answered. This is a Social Security Sestake trust action, which you are now a real party in interest to. This is a military admiralty jurisdiction under maritime law. However, you must realize that you have no such jurisdiction without also having a valid international contract in dispute. I am not aware of having entered in any international contracts, so I deny that any such contracts exist. Will you please instruct the prosecuting attorney to inform the court if there is such a contract? And if so, place it into evidence and explain how I'm party to it and then compelled to perform under it.
Let's take a moment to steady the tone here. There's really no need for anyone to get worked up during a court proceeding, especially when the focus should be on the facts and the judge's instructions. Everything taking place in the courtroom will continue at its own pace, and there will be plenty of time afterward for anyone to gather their thoughts or review their materials. Comments that escalate tension don't help the situation or support the arguments being made. What truly matters is maintaining clarity, staying composed, and allowing the legal process to unfold without unnecessary distractions or side remarks. School. That brings us to the conclusion of the first hearing. Fortunately for everyone involved, the situation didn't escalate, and there were no dramatic confrontations or claims of wrongdoing directed at the court. The judge maintained control of the proceedings, and the hearing moved forward without any major interruptions. However, things didn't unfold the way the defendant hoped. His effort to have the case dismissed was unsuccessful, and despite insisting that the court lacked authority over him, he found himself right back in the same courtroom the very next day. This return appearance made it clear that his jurisdictional arguments weren't accepted, and the legal process continued according to standard procedure. Moments like these highlight how courts rely on established law rather than personal interpretations, and the next hearing will show even more clearly how the judge responds when these arguments are repeated.
Your Honor, I may be challenging 1077 in this case.
I understand that the city's bringing up whether or not you're able to proceed in this matter. So whether or not you're able to understand the nature of the proceedings and be able to assist your attorney or to represent yourself, you have to be able to meet that threshold. And the fact that I think it's not that you don't understand, I think it's you choose not to understand, and that you have someone giving you information that you are spewing in court. So you're simply off base, but I don't know that it's due to a mental defect that is causing you to not be able to
challenge my competency because I have challenged the jurisdiction of this court, and you have not proved jurisdiction.
In Social Security or contracts
You
or
have to prove
maritime.
jurisdiction before we can move any further.
So that's just not how it works in this court, and I don't think you have the legal.
You must prove jurisdiction because I've challenged the jurisdiction. If you cannot prove jurisdiction, then I move to dismiss this matter with prejudice.
That's denied.
And so, Miss Jennifer, can you prove?
I'm Judge Grant, so I'm going to have you.
Can you establish the jurisdiction? Can you prove jurisdiction?
Ms. McDonald, I don't know that this is him not understanding.
I do not understand the nature or cause.
Well, he doesn't have legal training, so that I think is
that does not matter.
Well,
if I'm here sui juris and propria persona, I'm of my own right. I'm in my proper person. You've created a bond on this matter. You've attached my Social Security to this matter. You're trying to charge my trust without my permission, which is illegal. It's fraud, and I'm not going to stand for that. So you must prove jurisdiction before we can move any further. You've already tried to practice law from the bench, which is illegal. You cannot do. You've tried to assign counsel when I've given no power of attorney to anybody, and we cannot move further until you've proven jurisdiction.
The explanation is actually straightforward. The moment a person chooses to operate a vehicle on a publicly funded roadway, they are entering into a basic social agreement with the city, the county, and the state. Using public infrastructure comes with certain responsibilities, and those responsibilities are recognized under both common law and statutory law. This framework isn't new or unusual. It's supported by long-established legal principles and multiple provisions within the United States Constitution, including the 10th Amendment, which outlines the powers reserved to the states that are, in simple terms, once someone participates in a system that society funds and maintains, they are also expected to follow the rules that govern that system. Courts apply these laws uniformly, and opting into public services automatically places a person within that legal structure. Anyone wishing to avoid that arrangement would need to refrain from using those public resources altogether, because participation and regulation go hand in hand. This is why arguments about avoiding legal obligations while still benefiting from public infrastructure rarely succeed in court. They conflict with both constitutional authority and long-standing legal precedent.
So, Ms. McDonald, what I think would be the next steps, I don't know if Mr. Parent, have you been able to provide any assistance to him on a standby basis?
No, Your Honor, he doesn't want any assistance.
Okay.
So I'd ask to withdraw as a
So we
standby
could go
counsel.
through the colloquy, we can provide him with the form for rights. I don't know that he's going to choose to participate in that. But that would be the next step and set it for trial. So Ms. McDonald.
I don't have a problem setting it for trial. If he's going to waive counsel altogether, then I think we need to have him sign the waiver of right to counsel.
Absolutely. I'm just saying I don't know that he's going to participate in that process either.
Right. No, I understand
We have
that.
speedy trial at
It is the
August
burden
9th.
of the state to prove jurisdiction. The prosecuting attorney has not done that. And so what we have here is we need to dismiss this matter with prejudice. And I motion to dismiss this matter with prejudice.
Denied.
Based on the fact that the prosecuting attorney has not proven jurisdiction.
Mr. Schuster, would you like to sit at this table away from council so that we can hear you on the
This isn't
microphone?
counsel.
Well, you could sit at this table if you'd like. There's a pen and a form and a microphone for you if you'd like.
We cannot move until jurisdiction has been proven.
Yeah, this should be a,
You have failed to prove in jurisdiction.
Jurisdiction is something that we prove at trial. It is a factual issue as well.
We cannot move any further until jurisdiction has been proven. And none of you have done that.
Right. So Mr. Schuster, did the court say that was end of August or?
it was August 9th is speedy trial.
So
And if you plan on having me back here, you're taking away from my ability to provide and work.
It seems there may have been a key detail overlooked here. Earlier in the proceeding, the judge reminded the defendant that he was placed on a deferred prosecution agreement. That agreement only exists because both sides acknowledged that the court does have jurisdiction, and the defendant consented to follow the established laws of the state of Washington as part of that arrangement, though a deferred prosecution isn't something that happens automatically. It requires an individual's participation and formal acceptance. By entering into that agreement, he effectively confirmed that the court had the authority to oversee his case and to enforce the conditions tied to it. This creates a clear conflict between the claims he is now making and the commitments he previously agreed to. When someone accepts the terms of a legal agreement and later argues that the court lacks authority, it presents a contradiction that the record can easily reveal. The legal system relies on consistency, and once a person signs onto an agreement, the obligations attached to it remain in place.
And I cannot just be coming back here because it takes my time away from working. And so if you want me back here, it seems that you have Zoom port available. I'm more than happy to make a special appearance via Zoom, but you're taking away my time and freedom to provide for my family.
does the August term start August 6th, Your Honor?
It does.
So I would request we set it during August term.
All right, so Mr. Schuster, you've been charged with driving while your license was suspended in the 3rd degree and for operating a vehicle without the required ignition interlock device and refusing to comply with a law enforcement officer. You are on a deferred prosecution in another court, and the consequences are extreme for you. You are subject to another court, and they could very well
get in trouble. And you have to prove jurisdiction. You haven't done that, and you've failed
obviously
to do that.
you
over
believe
and
that
over and
courts
over
do
again.
have
And so,
jurisdiction over you.
Obviously, you have to be able to prove it, and you haven't. And you can keep pushing it and doing this, but it's just a waste of time for everybody. I definitely understand that this is not what you think it is, and this is just a waste of time at this point. So whatever you need to do to prove jurisdiction, but I know you can't. So if you want to waste more of everybody's time, go ahead, because obviously I'm not going to allow you to threaten me anymore, which you've done.
Nobody's threatening you.
Yes, you're telling me if I don't appear, that you're going to put me into captivity.
The argument here is clear. Repeatedly violating laws that one has already acknowledged as valid can directly interfere with a person's ability to work and provide for themselves or their family. Legal compliance is not just a formal requirement. It ensures that individuals can participate fully in everyday activities like driving, employment, and other responsibilities without risking penalties or interruptions. If providing for one's family is truly a priority, then following the laws that govern everyday life is essential. At a basic level, this includes taking steps such as obtaining the proper licenses and permits required to operate within the legal framework. Compliance isn't a matter of personal preference. It's a practical necessity that safeguards both individual opportunity and family stability. Courts often emphasize that choosing to engage responsibly with the law is the most effective way to protect one's rights and avoid complications that could limit future prospects.
For what's going on here, that's absolutely ridiculous. And so
I don't think
this matter
anyone
needs
is
to be
told that they're
dismissed
being
with
put into
prejudice, and
captivity.
whether we need to take this to trial or whatever y'all need to do to prove jurisdiction, I mean, go ahead, but obviously you can't prove jurisdiction. So
I'm looking for the more
waste everybody's
detailed
time, please.
counsel
Waste everybody's
waiver.
time. It's absolutely ridiculous.
I don't know that he's done that yet,
No, he hasn't. I have the streamlined version, but I want him the formal,
the detailed one.
the detailed one.
We can also, Your Honor, just set it for trial today with an intervening pretrial, provide him with that document and enter the waiver at the next hearing prior to allowing counsel to withdraw.
All right.
Counsel should have never been appointed because I've never gave my power of attorney to this counsel. And obviously you did that to practice law from the bench, Miss Jennifer, which is illegal. You cannot do that.
Mr. Schuster, you're charged with a crime that has potential jail consequences and fines.
Ms.
And so
Jennifer,
your rights need to be protected.
Her-
This is for
nobody-
your benefit.
There is no injured party. There is no sworn complaint of an injured party. This is absolutely ridiculous. It's a waste of everybody's time. And you're taking away my ability to work over and over and over again. And I won't stand for you violating my rights.
The first attempt to challenge the court's authority didn't succeed, and all signs suggest that a repeat effort is unlikely to yield a different outcome. The court has already reviewed the arguments, and the legal framework remains clear and consistent. At it appears that the judge is prepared to address the matter further, ensuring that the proceedings continue according to the established rules. Rather than focusing on attempts to circumvent the system, the upcoming instructions will likely guide the defendant on how to comply with the law and move the case forward. This is a reminder that persistence alone cannot override legal authority. Understanding and following the court's directions is essential for resolving any case successfully.
And if you're going to acquiesce, then okay, you're proving that you don't have any jurisdiction.
Here's the part.
So this is a detailed advisement. Should you wish to waive your right to have counsel present and you want to act as your own attorney.
I said over and over again that I'm here sui juris and propria persona. You know what that means.
This case is going to be going to trial, so you need to have counsel. If you,
I'm here of my own right in my proper person. You know what that
so
means.
there's the form.
I've
for you
never
to-
signed my power of attorney away to anybody, especially this.
You need to be respectful. You are really out of
I
line,
said
Mr.
this.
Schuster.
I didn't say anything disrespectful.
You are being
This
very
person-
disrespectful.
You
to
were
the
being very
court.
disrespectful, actually,
the court
because
and to Mr. Parent.
you're violating my rights.
So I'm
forcing
going
me
to set
to
this on
come
for the
in here
August term. I'm going to
over
have
and
you
over and
take
over
this
again,
form.
wasting my time.
Mr. Schuster.
And you're taking away my
I'm going-
ability to provide and work. Because
Have a
this is
seat there so
free-
you can fill out
free
this
place.
form.
What's that?
You can have a seat there so you can fill out the form.
You're dismissed. Do you need anything else?
Yes, I do. I need you to take that form. So we're gonna have to go through that because this case is gonna be going to trial. It's gonna be set on the August term. That would be August 6th, and that will be at 9 a.m.
All right, you're dismissed.
It would be wise for him to get a clear understanding of the situation quickly, or accept assistance from the court-appointed attorney who can explain the consequences in detail. As discussed earlier, he is currently on a deferred prosecution agreement, and that status carries significant responsibilities along with strict conditions. If he is ultimately found guilty of the charges he's facing now, the judge will be allowed to consider his behavior in the courtroom, including any refusal to follow instructions or cooperate with the process. That could influence the severity of the sentence, and courts do take conduct into account when determining penalties, because this case exists alongside a deferred prosecution. A conviction could trigger both the consequences of the new charges and the penalties attached to the earlier agreement. In other words, he could be required to serve the sentences one after the other, rather than at the same time, resulting in a much more serious outcome than he may realize. This is why understanding the legal stakes is essential, and why cooperation with counsel and the court is often the best path forward.
No, you're not free to leave yet, Mr. Schuster.
I'm not free to leave.
Not yet. No, you're not.
Why am I not free to leave?
Because we are still addressing your matter.
This matter needs to be
Yeah,
dismissed.
it's not going to be dismissed right now. So
That's
right now it's getting
dismissed
set
because
for
you cannot
trial.
move any further until you prove jurisdiction.
And the readiness hearing will be July 31st, and that will be at 2 p.m.
don't
And
have
that
any-
hearing, Mr. Schuster, is on Zoom.
Any jurisdiction over me whatsoever. I've not pleaded. I've not given you personal jurisdiction.
Yes.
And you practice law on the bench.
So, Mr. Schuster, if you choose not to come to your court hearings, a warrant will issue for your
And you're
arrest.
threatening me again, telling me
Yes,
if I don't
you will be
play your
expected
game,
to appear.
and you just said yes. Oh my goodness. That if I don't play your game, you will put me in captivity. This is ridiculous. Absolutely ridiculous.
Yep, these are jailable offenses, but for this
Absolutely
hearing,
ridiculous, Ms.
we need
Jennifer.
your presence to appear.
Absolutely ridiculous.
All right, let's get a court date form for him.
Absolutely ridiculous.
What's the date for the intervening pre-trial?
Could you back there?
We can set a pre-trial. Let's do it on the 22nd.
Prosecuting attorney also needs to provide any contracts that I've entered into internationally,
Here's your court date. Could you please sign? for that?
especially if this is an admiralty maritime jurisdiction, which obviously by the gold fringe flag it is. So
Mr. Schuster, you are in a criminal court and there are court rules. If you wish
criminal
to
matter,
have.
this is a criminal matter, you said?
Mr. Schuster, if you wish to have discovery, then you need to abide by
You said
the
this is
rule.
a criminal matter?
Yes, and if you wish
Yes,
to have.
these are-
Oh, okay. I wasn't sure you said that. Thank you.
That wraps up today's coverage. There are a few upcoming court dates in this case, and I'll be providing detailed updates and in-depth commentary as events unfold. You can count on thorough analysis, clear explanations, and real-time insights into each hearing. If you found this breakdown helpful, make sure to show your support by hitting the like button. If something didn't resonate, you can hit dislike, but leaving a comment with your thoughts is the best way to engage and share your perspective. Don't forget to subscribe and turn on notifications so you won't miss any future updates or analysis. This is Team Skeptic, keeping you informed with accurate, engaging, and straightforward court coverage. Thanks for watching, and we'll see you at the next hearing.
Criminal matter. If you wish to receive discovery, then you will need to make.
What is the jurisdiction? Are we under an admiralty maritime jurisdiction?
No, we are not. Mr.
Are we under
Schuster.
a common law? What jurisdiction are we under?
We are under the criminal jurisdiction of the state of Washington. So if you wish to have discovery,
Not a
then
jurisdiction.
you need to request,
I gave you my permission to be under that jurisdiction, which I haven't.
you will need to request discovery from the prosecutor's office.
I'm not a U.S. citizen, American national. That's not a jurisdiction.
If you wish to have discovery, you need to request it in writing from the prosecutor's office and we will
You said your
send.
nationality was a U.S.
And then
citizen.
we,
Is that what you
and then
said
we will,
earlier?
and then we will, We will send you the discovery,
No.
all of the evidence that we have against you at trial. Did you understand that?
I don't understand what's
Okay.
going on with this.
So,
This is ridiculous.
here's my
Kangaroo
suggestion,
court.
Mr.
Absolutely.
Schuster.
Kangaroo
Mr.
court. And so since
Schuster.
you guys are gonna waste everybody's time even more, goodbye.
Mr.
Mr. Schuster, you
Schuster,
need to sign for your court dates. I'm giving them to you orally.
Have a good day. Talofa.
If you don't appear for your court hearings that were given today, a warrant will issue.